13A District Court for County of Washington, State of Michigan is now in session. For the court draw near, the Honorable Judge J. Cedric Simpson presiding.
You may be seated. My apologies for my tardiness, folks. Pardon? Can you do what? Who are you? I think she is representing you.
And I've been here all this morning.
And so what would you like me to do? Well, I'm looking at you, but you mean call your case?
Yes, sir.
You have an attorney.
Yes, but
It would be unethical for me. It would be unethical for me to call the case when I know you have an attorney.
she's playing on another case.
You know what? You can go out there and tell Miss Bauer, go out there, tell Miss Bauer that you fired him, then you come back in and you can represent yourself as soon as she lets me know. Court's going to stand in brief recess. I'll come out and deal with Ms. Rose and Mr. Ping. I will deal with you in a moment. You don't want to deal with me right this second. Court is standing in recess.
All rise.
I wanted to address Bond for his.
Yes, go ahead.
He has been contacting the victim.
I'll just go.
In this case, I'm also asking you to report his jail phone call privileges. He's made he's called her 195 times.
What?
Yes. And
Did you say 195?
yes.
Oh.
And even one of the calls, he said, email the judge and the prosecutor and the lawyer. And that day we received the email from the victim.
Oh, that's a lie.
Stop.
That's a fucking lie.
Hey. Oh, no, we're not going to say that here. Phone privileges are hereby ordered revoked.
Okay.
Defendant's bond is set at no bond.
I don't give a fuck.
Okay, he's now in contempt. That's 93. Anything else?
I think at this time,
Okay, I'm gonna need an order. Contempt. You got 93 on that. His bond's been revoked. It's 0, and he's got a preliminary examination. Good luck, Judge Washington. Court calls the case, People versus Jaquan Turner. You probably don't want to come out here right now, do you? No.
The back today, Your Honor.
Yes, that's the bond.
There's the strangulation case in a DB when he was arraigned on June 13th, 2020, he called his friend, then after he was told not to contact the victim, he called his friend to ask and gave the friend the victim's phone number and asked the friend to have the victim bond him out or to give him money to bond him out. So I'm concerned about the fact that he was ordered by the court not to contact the victim, and then he went ahead and did that prior to being bonded out on the 13th jail call. We had originally asked for a $250,000 bond in this case, and he was given only a $25,000 bond. So I am concerned about that.
But yes. Mr. Crater.
Madam Prosecutor said she sent me, and I'm sure she did, but I've not received the audio of the jail call, so I cannot respond what's in it, what's not in it. What I can tell the court is that
there were calls made to the victim.
I can't represent that. I haven't heard them. I guess
I want to make sure I'm hearing what I think I'm hearing.
There were calls made to third party, telling the third party to contact the victim and giving the victim phone number to the third party. That was the same phone number in the police report.
Got it. Okay. Go ahead.
All right. So I cannot speak to the phone call because I've not heard the recording of it. What I can tell you is that I have yelled at my client, admonished my client if that did happen, he's not to have any contact with the victim. He's not to contact or have a third party contact her in any way or fashion.
Well, why did he do that in the first place?
I don't know if he did or he didn't. It's the first I've heard of it.
Go ahead, go on.
He explained to me that he did make a call to his friend Ali to have funds released so he could be bonded out. That's what my client tells me. I don't have the jail
So
costs.
he's saying that he didn't have any contact with or direct anybody to have contact with the victim in this case? Is that what you're representing to the court?
If I could have a moment, Your Honor.
Yep.
I'm sorry. Did you tell him the witness? Did you say that? Did you say that? So you did do that? Yes. Okay. Your Honor, after conversations with my client, he states to me that he did ask his friend to contact the complaining witness in order to release funds to have him bonded out, Your Honor. He understands that he shouldn't have done that. I've yelled at him about that. I've explained to him that he cannot have any contact with the victim. He did not, on that jail call, from listening to Miss Blanche's details, tell her not to show up, tell her not to cooperate. So I would ask that he be allowed to remain out on bond, Your Honor. I hear you. I can't hear you. Sure. And he wanted me to continue to say that he is fully employed, has a job waiting for
I
him.
understand that, but he's given certain conditions regarding his bond and just willfully violates. Defendant's bond is modified. Defendant's remanded. Defendant's bond will be set in the amount of $100,000 cash share.
Thank you, Your Honor.
Oh, I'm sorry, Judge.
Your Honor, Ms. Convertino and I are both available. I'm sorry, I knew her as Miss Joseph, and I said still when I try to call her Judge.
Okay.
We're both available on the 9th.
So? No.
At least you have water now, Judge. You know.
Yeah. Wow,
You sure it's just water?
Wow. Really? Wow. Goldstein said that. It is water. And now we're going to make him drink. Preliminary examination in person. Wow, David. July 9th, 2024, 9 a.m. before Judge Burke.
Yeah.
Thank goodness that was not me. For David's sake.
And my client's sake.
No, he would have been fine. You would have had problems. All right, bond will continue.
Thank you, Judge.
There is one
Okay.
issue.
Yes, sir.
Detective Luke obtained a search warrant for the defendant's DNA. They attempted to effectuate that in the jail. The defendant refused to comply and would not let the detectives take a buccal swab pursuant to that search warrant. They are present here today. I'd ask that either the court could order him or it could be effectuated up here. The best way to handle that, but they were running into issues with the ability to obtain his DNA.
Judge, I don't think the court needs to order it at that time. At this time, I've spoken with my client about it. He will provide his sample today pursuant to the search warrant.
He'll do it right now. You guys can go back there. You can do it. Let me know before I continue to respond on this case or have the 7th or the 9th as the day. I want to make sure that that has occurred because otherwise I'll start moving things around and readjust the bond in this matter. What do you expect me to do? In another court where?
I believe it's Wayne County. I could be wrong.
Who's his attorney?
Green Johnson.
Sir, I don't have your attorney. He was here on Zoom. I don't have him here. I don't know where he is right now. I'm going to send you back. We'll get your case called today, right? And either it'll be with this attorney or somebody else, because I'm not putting up with this.
Okay.
Got it?
Yes, sir.
Bond continues.
Well, Your Honor, it appears we
Go
are,
ahead. You want to argue bond?
I do, Your Honor,
Go
and
for
it appears we are here on a bond violation as well. I don't know if that's what the docket said is. And the only information, Your Honor, I have with regard to the bond violation was that he was taken into custody on an alleged no contact violation that occurred at his house, where my client advises that the complaining witness showed up. He asked to leave. The police got involved. He was taken into custody as a result. I don't know exactly how that all came about. I believe that some yelling occurred. The police were called. He was taken into custody as a result. Your Honor, he does reside in a home with where he lives without the complaining witness. He is asking for some consideration there. He understands that he's not to have any contact. As far as I'm concerned, and as far as I know, he did not intend to have contact that day. She came over. It was inadvertent in that he now knows that he cannot have the contact. He does have a 3-year-old daughter. He shares custody with the child's mother.
Did you request a hearing on that? Because I had already, I think, addressed this.
I thought you may
He
have.
increased his bond at the last hearing.
That was our impression too. I don't have any additional information if there was additional violations or anything alleged. I don't see anything in our file from community corrections indicating that there were additional violations. I was under the impression that this was addressed when Ms. Hughes handled it.
I thought it may have been too, Your Honor. I just saw that it was set for a bond violation hearing today as well, and I did want to put up a bond argument on behalf of my client. I would ask. He has been in jail for the last 9 days, Your Honor. I would ask for home confinement if the court would consider that. He knows he can't have contact with her. He didn't intend to that day, and he, for all intents and purposes, wants to keep that contact from happening.
Okay, having heard nothing different from the last time, there's nothing that's going to change the court's position in the bond in this case.
Okay.
This motion for bond reduction is denied. Bond will continue. Thank you.
Oh, Your Honor. Finally, I just real quickly, he is on a tether. I don't know that since he's in custody that's necessary. If we could at least have that taken off or some consideration for that to be taken off of him.
We'll leave that to jail.
The jail.
He's now.
Your Honor, the jail is leaving that to the court, is what I've been informed of. The jail won't do anything without an order from the court.
I don't know. I don't see that he has any other cases pending, so.
I don't know that. I don't know. Is this the only case that he's got a tether on?
This is the only case that he has a tether on.
Well, they can take the tether off. They
Okay.
want the tether back. I don't care. He's not going anywhere.
Thank you.
If he leaves, he has to have the tether put
Understood.
back on. He understands that.
Thank you.
Your Honor, today is.
Before I forget, happy birthday tomorrow.
Thank you, Judge. I appreciate that.
Yeah.
You know, I feel like now, like that I got a happy birthday from a celebrity judge like you. I feel like that makes me a celebrity defense attorney by proxy,
Wow.
right?
Wow. Wow. Here's what.
I feel very blessed.
No, I don't know what you did. My staff, it's all over my calendar. I woke up this morning, I saw it on my calendar, I said, who the heck is this? I don't even, but anyway, okay. Well.
But you didn't know my name? I'm a now. No, I'm kidding. But
I'm not biting on that. Go ahead.
Today is the date and time set for PCC. At this time, Your Honor, we would like to request one more PCC to see if we can reach a resolution in this. And I would also like to address bond.
Okay, how much time are you going to need to see?
1 week or 2 weeks, whatever is well, the second one would be the 4th. So 1 week, please, Judge. Because it would either be 1 week or 3 weeks, correct?
1 week, 3 weeks. I also have July 2nd.
We'll do 1 week. So I'm here next week if that works for Your Honor.
It doesn't, but what the heck?
Thanks.
June 27th, 2024. 9 a.m. Bond continue. Well,
Yes, Judge.
Bond.
Bond in this matter is currently set at $10,000, 10%. My client is not able to post that. When we were here last week, there was 2 additional bonds. Those bonds were both lower to $1 each. My client cannot, and not in this case, Judge, in a different matter. So, Your Honor, my client, I did talk with him. He is able to post $100. So, if Your Honor would consider lowering to $1,000, 10%, he would be able to make that.
Any response from the people?
Thank you, Your Honor. When my office charged this case, we requested $15,000 as his bond, and defense counsel is correct. It was currently set at $10,000, 10%. At the time that he was arrested for this case, he was in bench warrant status for 2 cases. What's notable about the bench warrant status is that he had been in bench warrant status since August 12th, 2019. In one of the cases, it was his third failure to appear in a row on that file that bench warrant then issued, and then he just remained in the wind since 2019. In the other file, his failure to appear to his other warrant was actually for him failing to appear for a violation of probation hearing. So this is not a person who does well out on bond. This is not a person who typically follows court orders, and absconding for multiple years with 2 warrants out for his arrest, he was in possession of a gun. So, Your Honor, at this time, I believe that reducing the bond even further would not be appropriate, especially given that.
Your Honor, if I may just briefly respond. With this case, there are 3 defendants. There was 1 gun allegedly in a vehicle. 3 people have all been charged with CCW. So possession at this point is just an allegation. And then further, Your Honor, if coming to court would be the issue, which I completely understand from what Ms. Hughes just placed on the record, I think a GPS tether would suffice in letting us know his whereabouts and that he would be here at court.
Well, at this point, we're set for next week. I'm going to deny the motion for bond reduction. I'll just keep it the same at this point. We can take a look at it depending on if there's something.
Thank you so much, Your Honor.
Thank you. As to bond.
Yes, Your Honor. We are asking the court to respectfully reinstate my client's bond or consider issuing a bond, perhaps in the amount of $10,000 with 10% provision. There were 2 issues regarding his bond. It's my understanding there was a bond violation for some missed tests, and also for a violation of the no contact order. Spoken with my client about both of those allegations, and he does admit to both. He indicates he did violate the no contact order. I would like to give the court some background on that. However, the date that he violated the no contact order, he indicates that he received a text message from the complainant saying, "Come grab your stuff," from the home. He went to grab his items from the home, and an anonymous caller then contacted police indicating that he was present at the home. And so, yes, he did have contact. He did go to the home, and that is the circumstances surrounding that. With regards for the missed tests, he has simply put no excuses for those. We've discussed the nature of this case and how serious it is, and that he does need to test. He will be testing in the future. He will not have any other issues with testing. He has indicated to me, should he be released, he would reside in Belleville with his father and his stepmother. He will also be working with his father. They do fencing, installation, and repair. So he will have gainful employment as well as family support.
Not sure I'm going to need a response, because the problem, I hear what you're saying, counsel. Problem is, he was supposed to be testing. He's not. He's been missing his testing. And the other thing is that he is apprised at the time of arraignment that if he needed to get his items, then certainly he could do that by use of a civil standby, and he failed to take advantage of that and decided to engage in self-help. So his bond will not be reduced to what you're asking. I will set his bond at a $50,000. I'll give a 10% privilege on that, but
10%, 50,000, 10%, 9,000. Oh, there's okay.
All other conditions remain in place.
Thank you, Judge.
That was a waiver, so I think she needs to sign something. Court does call the case People versus Counsel. You guys are going to have to not talk to your client when they're on their way out. These guys got to move these people in and out. Court calls the case. You're not the only one that did it, Ms. Constantino. It wasn't at you. But yours was most egregious. Court calls the case People versus Tyler Stafford.
Briefly address bond. Be very quick.
Go ahead.
Your Honor, Mr. Warren's bond is currently set at 10,000, 10%. He is unable to post that bond. To my understanding, his only prior is resisting and obstructing from 2010. He did have, I believe in this case, he did have a prior failure to appear. He was in and out of hospitals, and that's why he wasn't able to be brought in. And then he did rehab and completed rehab twice successfully. He will, we've talked about this. He will show up at all future court dates. He does want to get this.
How did he come back into custody?
Pardon me?
How'd you come back into custody?
I was at the Ann Arbor Comprehensive Rehab, Outpatient Rehab, and they picked me up. The police picked me up.
You didn't turn yourself in?
No, that was on my agenda.
Yeah, I'm sure it was. Anything else?
Nothing further.
Motion for bond reduction denied. What's that? What's that mean? Aren't you keeping track? All right, I'm done. Court stands in recess.
All rise.
Wow, this water was good. Part-time Ron Brown or Lauren Brown.
I was hard at work, Your Honor.
No, they told me you were gone. Well, actually, the way the whole conversation went is he's gone. You know, he don't work the whole day. Actually, the person I think that said it was Children. Yeah, that's the one he said. Oh, he's long gone. Yeah. He just said Lauren doesn't work the whole day. I will say this also, Mr. Brown.
One of them said.
No, it was Childers. It was Childers that said it. I will say the thing that I was shocked about was that Joy Gaines did not jump to your defense. She did not. She absolutely did not. Hey, that's it for that block? Wow. Emily, you are the bastion of efficiency.
I know.
Wow. And humble. All right. Court is standing in recess.
All rise.
Hello.
Hi.
She's here.
I'm
All
back.
right. You're back. All right.
I was with you this
And-
morning, too early.
Yes,
remember?
ma'am. No, I remember. You were here at like 9.
I just like
All
watching
right.
your courtroom. I'm just gonna log in every day because you crack me up.
Okay.